Hello, everyone. My name is Shelley, and I'm an estate planning attorney, and I'm the CEO of iWillandTrust.com. iWillandTrust.com is the first and only attorney estate planning website. There are many non-attorney sites. They will have you believe that there's an attorney involved, but there is not. They're just forms that you populate online, and as a result, they are not customized to your situation. Whereas when you use iWillandTrust.com, after you've submitted your answers, an experienced estate planning attorney in your state reviews your information, provides legal advice, and customizes your documents for your situation. All of your documents are included for the same low fee: the will or trust, powers of attorney, healthcare documents, living wills, and more. It's a great deal because if you engaged an attorney the traditional way for the same service, fees typically range from $2,000 to $5,000 on average, depending what city you live in and the circumstance. But with iWillandTrust, you can complete this much more affordably and easily and with an attorney. It's the only one of its kind. So today at iWillandTrust, we're talking about the differences between wills and trusts and two types of trusts so that you can decide what is right for you. Then I'll walk you how to choose one of these when you use iWillandTrust.com. If you have a question, please comment below at the end of this video. I will try to answer them. Comment below anytime, but at the end, I'll try to answer your questions. What is the difference between a will and a trust? Okay, so choosing between a will and a trust may seem difficult, but at iWillandTrust, you will be able to do so with help. Here's the pros and cons of each. Let's start with a simple will. One, a simple will is a short and simple document that states where you want your assets to go in the event of your death and who you trust to execute on those wishes. For example, a simple will might be summarized as, I want all of my assets to go to my wife, and if she is not living, then equally to my adult children outright. My wife will be my executor, and when we're both gone, we've both chosen my brother as our executor. A simple will is nice because it's simple, it works well to govern distribution of your assets, and it's nice and short. It does not avoid probate after your death, usually, and we can talk about that in a minute. We'll talk about probate in a moment. So first, let's talk about trusts. Like a will, a trust states where you want your assets to go in the event of your death and who you trust to handle those distributions. So a trust is longer and can provide a few additional benefits that a will cannot. One, strings attached. So if you wish to place conditions on the gift or slow down its distribution, a trust can do that. So for example, if you want to say, well, I want all my assets to go to my wife and then to my children, but I want the assets held in trust and for my trustee to determine for my children when and how much to distribute to them and for what purposes. So strings attached is something that you can do with a trust but not a will. Creditor protection is the second thing, and that is creditor protection for your beneficiaries. So while your assets are in trust after your death and held there for your loved ones, if you've named an independent trustee, and this varies by state, then your beneficiaries' creditors are less likely to access those trust assets. Now, if you want to attach strings or to use creditor protection for your beneficiaries, there is an expense during the years after your death when assets are held in trust and administered in trust by a trustee. Obviously, that creates some administration and some expense. The third thing that some trusts can do, and that is living trusts, is help you avoid probate in the event that the living trust is fully funded at the time of your death. So you create your living trust now, you transfer your assets into it, and we'll provide you some information on how to fund your trust. And then at the time of your death, your successor trustee will not need to open a probate to gain access to follow your wishes. So I said I would come back to probate. Probate varies in each state. Here in Colorado, where I'm sitting, the personal representative fills out 4 or 5 forms to open an informal probate with the court and gets back from the court what's called letters testamentary, which is a document that allows that fiduciary to do things like sell a house or close out a bank account. The fiduciary also has to notice creditors in the newspaper, do an inventory and accounting, and perform some other tasks. And then as early as 6 months after it's opened, the personal representative or fiduciary can close the probate with some more forms. So that's what a snapshot of probate here in Colorado. It varies by state. In California, for example, it's a little bit more tedious than that. And so in California, a lot of people do have living trusts. So that's what probate is. Keep in mind that if you're married and as spouses, you have everything titled jointly or payable by beneficiary designation to each other, a probate would only occur when you're both gone. So you'd be saving your loved ones the trouble of probate, but maybe not yourselves. So that's what probate is. If you feel strongly about avoiding probate, then you would consider a living trust. The disadvantage being you do need to get assets into your trust, and for each type of asset, that process varies. So there's a deed, which one deed can be completed on iWillandTrust. A deed on your house goes into your trust. Maybe some bank accounts need to be made payable to your trust. So there's some homework involved in using a living trust properly. So those are the pros and cons of a trust versus a will. And I wanted you to know that besides the living trust, there's also another kind of trust called a will with a testamentary trust. The will with a testamentary trust is where the will is written with the trust that is inside of it. It comes to life only when you're gone. So maybe a young couple with kids might have a significant amount of life insurance, and they say they want everything to go to each other, but when they're both gone, they want it to go to the kids, but in trust under the following terms. You can do that with a will with a testamentary trust. That will not avoid probate, though. So that is an option. Either the will with the testamentary trust or the living trust can include so-called strings attached that we talked about, or the creditor protection for your beneficiaries that we talked about, but only the living trust can avoid probate if it is fully funded, so your assets are in it at the time of your death. And remember that the disadvantage of any trust is that it causes some work and expense during the years after your death when the assets are held in trust. So let me show you how to choose one using iWillandTrust. And I'm about to share my screen with you so that you can see what it looks like to use iWillandTrust. So when you first use iWillandTrust, you will see some information about the website, some videos. You will be able to look at reviews that have been provided by other users of the site, and we've had a lot of people who really appreciated using the site and very happy customers. You'll also be able to see some videos on how this works and what it means to create an estate plan, and some very useful information. Now, when you're finally ready to begin, you'll click Begin, and you will register and engage the attorney, and then you will be asked to provide some information. So you'll provide some personal information. It's all confidential. You will engage the attorney at this point, and you will also provide some information about your assets. Now, it doesn't need to be very precise. You don't need to do any preparation to use the website. Very general information and rough numbers. And the reason for these questions is that the attorney needs to know how things are titled and currently payable by beneficiary designations in order to give you the right advice. So the titling is kind of the main reason why these asset questions are here. Then you'll say how you would like to leave your assets in the event of your death, and you'll choose who you trust to handle that. There's videos along the way that really give you some good information about how to make these choices. You'll also choose who you trust to handle healthcare decisions. And then here, and I'm skipping over a lot of the questions, but I'm just getting you here to where you'll choose between a will and a trust. There is a video here that has a lot of the same information that we just talked about. So if you want to review what we talked about in today's webinar, you would click on this and watch a video. And then when you're ready to choose, here's the page that you would make that choice. Now, just to recap, your three choices are simple will. That's a nice, simple, short document that works well to govern your assets and how they're distributed. It does not allow for slow distribution of your assets or creditor protection for your beneficiaries, nor does it avoid probate. And then you have the option of a will with a testamentary trust. It's a will with a trust written in that comes to life only after your death. It can provide slow distribution of your assets and creditor protection for your beneficiaries, but it will not avoid probate. And then lastly, you have a living trust, which can provide slow distribution of your assets, creditor protection for your beneficiaries, and can avoid probate, but only if you have transferred to it all of your assets at the time before your death. So all three work well to govern how your assets are distributed, but regardless of what you choose, the attorney who prepares your documents can change this choice or make a recommendation for you. So go ahead and choose. And remember, you can come back to this guidance when you're ready, and you'll be assisted in making the right choice. So when you're all finished, you will click submit here, and only then will you be able to communicate with an attorney. So please don't try to contact the attorney before using the site or to ask any questions before using the site, because the attorney, having not been engaged by you through this process, will not be able to give you advice. So go ahead and use the site. It takes about 30 to 45 minutes to answer all the questions that I just showed you. And then you'll be able to get advice and customized documents, which will be sent to you within a few days.